Idaho student murders. So we had 4 students that were murdered. This was back in November. All were found stabbed to death, unfortunately, and there were 2 surviving roommates. They were able to find and arrest Brian Kohberger roughly, I don't know, was it like 6 weeks later? I think it was like the end of December. It was almost like the new year. But they were able to find and arrest Brian Kohberger. He was all the way in Pennsylvania. Apparently, he had taken a road trip with his dad from West Coast all over to East Coast. And they brought him back over to... What is this? Oh, I just got a notification. They brought him back over to Idaho. So he's currently going to be standing trial right now. They had his trial set for, I believe it was October 2nd. October 2nd, yeah. So he was supposed to have I believe a preliminary hearing at the end of June, but that was canceled because they were able to get a grand jury indictment. I think that's a phrase to use. And basically, Brian Kohberger and his defense team are requesting grand jury materials, and they're planning on contesting the indictment. So because of all that, I think they talked to the courts, and the courts gave him a, what is it called? An order staying time for a speedy trial. So they essentially gave an extension of, I believe, like 37 days. Yeah, 37 days. So that's just a quick little rundown, but I do want to read the court document because I think it is pretty interesting. In this court document, there is the word awesome in it, and I've never seen the word awesome in a court document. I don't know if it's a typo, but I thought it was kind of interesting. It made me giggle a little bit, but I was like, is it appropriate to have the word awesome in here? Or were they just trying to be a little, I don't know, maybe they're trying to be facetious and have a little bit of humor. I don't know. Oh, the Chapin stuff. Yeah, we'll get to that like very quickly in a second. I think her trial is going to happen next week, but we'll see. I don't know. A lot of these trials are getting pushed back. So starting with Kohberger. This was yesterday, actually. Yeah, yesterday. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully requests that this court reconsider its order staying time for speedy trial. The law does not allow the defendant to partially waive his statutory right to a speedy trial, and thus his acquiescence to the limited stay in this matter could be deemed a full waiver of speedy trial, with the potential to create needless litigation in the future. Additionally, the court stay has no practical effort where A, the parties are continuing to litigate discovery matters and file motions, B, trial remains set, and C, defendant is free to request a stay in the future. Due to these practical considerations, the state respectfully requests that the court rescind its order staying time for a speedy trial. The state further requests that the jury trial in this matter remains set for October 2nd, 2023. So October is like, I don't know, less than 3 months from now. And again, the murders happen in roughly like almost mid-November, I think. The state makes these requests to give the parties, the victims' families, and the witnesses predictability as to future trial dates to protect the record and to avoid needless speedy trial litigation down the road. So here's the background on this. Defendant was indicted on 4 counts of first-degree murder, 1 count of burglary because he entered the residence on May 16, 2023. On May 19th, defendant filed motions requesting grand jury materials, including the record and the transcript. In the days that followed, the state and the defense conferred but were unable to reach an agreement as to the scope of the grand jury materials subject to release under the Idaho criminal rules. You think Court TV is streaming but not positive? Oh, for Taylor Shabiz? On June 13, the defendant filed a motion to stay proceedings, arguing that he intends to contest the indictment and asking the court to stay this case so that he could discover the grounds upon which to do so. The sole legal basis offered by defendant at his request to stay was Idaho Code 2-213, which allows a party to request a stay in proceedings where there has been a substantial failure to comply with the applicable law in selecting the grand jury or trial jury. On July 10th, 2023, so a couple days ago, the court issued an order for a limited stay of the proceedings. The court rejected the defendant's rationale that the Idaho Code 2-213 applies at the stage. Nevertheless, the court elected to issue a limited stay to a whole speedy trial for a period of 37 days, relying upon the good cause language found in Idaho Code 19-3501. As the court noted in its order for a limited stay of proceedings, Kohberger and his counsel agreed to the terms of the stay on July 16. So the thing that I like about these court documents is sometimes when we're reading this, I'm just like, oh my God, what are they saying? This is like going above my head. But usually later on, they kind of like explain everything pretty thoroughly so you can kind of like digest it a little bit. Sometimes you got to look up these legal terms though, because you're just like, what the heck are they talking about? The sole basis offered by defendant in this request to stay was Idaho Code. Oh, wait, I already read that. Sorry. I lost my spot right here. Okay. As the court noted in his order for a limited stay proceedings, Kohberger and his counsel agreed to the terms of the stay on July 6, 2023. Acknowledging that he could not later argue that his right to a speedy trial was violated, so long as he is brought to trial within 6 months speedy trial period, plus the additional time period of the stay, 37 days. Trial remains set to begin on October 2nd, 2023. Here's the argument. Idaho Code 19-3501, which allows a court to dismiss a case for lack of a speedy trial, is triggered if the defendant whose trial has not been postponed upon his application is not brought to trial within 6 months. From the filing of indictment of information. Oh, also, I don't think Murdoch waived his right to a speedy trial, right? That's why Murdoch's trial happened so quickly. Man, because that one happened pretty quickly. Yeah, I don't think he waived his right to a speedy trial. Oh, thanks, Gelosity. I actually finally got my glasses fixed, and the guy, in a very nice way, made fun of how I wore my glasses because I didn't know how to do the nose bridge. The nose bridge was pinched so close and my glasses like sat up here, and he thought it looked funny. And I was like, please fix it for me. I've never really worn glasses before. So, okay, so Idaho Code, let me read this part again, which allows a court to dismiss a case for the lack of speedy trial. It's triggered if a defendant whose trial has not been postponed upon his application is not brought to trial within 6 months. Idaho Code 19-3501, 2, emphasis added. Notably, 19-3501 does not require an unequivocal, on the record waiver of a speedy trial. Again, they're accusing Kohberger of like not really completely waiving his right to a speedy trial. He's like sort of waiving it. And they're like, no, that shouldn't go down. Instead, the statute by its own language excludes from relief those individuals whose trials have been postponed upon their own application. So it excludes these people, and they're going to explain another case where this happened. State versus Lundquist is instructive. There, the Idaho Supreme Court held an individual who requested a single trial continuance beyond the speedy trial period in order to substitute counsel, but objected to further continuance, had fully waived his right to a speedy trial. So I thought this was kind of interesting. Lundquist's arraignment took place on January 4th, 1996, and his jury trial was set for July 9, 1996. So within the 6 months, ish, kind of, sort of. On April 18th, 1996, Lundquist filed a motion to separate his trial from that of his two co-defendants. That motion was granted on May 31st, 1996. Now, because Lundquist had not waived his right to a speedy trial while the co-defendants had, on June 14, 1996, Lundquist moved to substitute a new attorney for his one of two defense attorneys representing him. The court determined that Lundquist would be allowed to substitute counsel if he agreed to a continuance of his trial and waived his speedy trial rights. Lundquist and his counsel had concerns that Lundquist would be tried with his co-defendants in the future if he were to waive a speedy trial. So he put in a motion to not have his trial, basically not be tried with the co-defendants. And they're like, okay, you won't be tried with them. But now he's like, well, I want to substitute one of my lawyers for someone else. And the court's like, well, that's going to kind of like push back your trial a little bit. So you might have to waive your rights to a speedy trial. And he's like, well, I don't know. I'm assuming it's a he. They didn't want to because they didn't want to be tried with the co-defendants in the future. Now let's see what happens. However, the court noted that the co-defendants were not prepared to proceed to trial and had to request a trial continuance to January 1997, whereas the court could set Lundquist's trial earlier in August or September of 1996. Now, however, sometimes things don't really go as planned. So he's like, okay, or they're like, okay, so my trial's going to happen in August or September. I should be fine. As long as it happened in January, where they're also trying my co-defendants, hopefully we don't get lumped together. Now, Lundquist then agreed to the continuance and waived his right to a speedy trial. His trial date was continued to September. However, in August, the state moved to continue the trial in order to prepare a response to a report from a defense psychologist. See, you never know what's going to happen. There's going to be things that pop up and it's going to be, it's going to end up postponing your trial even more. Now, Lundquist objected to the continuance, arguing that the state had time to prepare. However, Lundquist offered not to call the psychologist if it meant there would be a continuance. Nevertheless, the court granted the state's request of continuance and set trial for January 8, 1997. So at this point, Lundquist is like, oh, shit. Oh, man. Now, on August 8, 1996, the state, I wonder if the state just did this on purpose. The state made a motion to consolidate Lundquist's trial with that of his co-defendants, and that motion was granted. That is what they did not want. Oh, man. Ultimately, Lundquist's trial did not start until January 29, 1997, a year and 25 days after he was arraigned. On appeal, so I'm assuming maybe he was found guilty with his co-defendants and they tried to appeal at this point, or he tried to appeal. On appeal, Lundquist did not contest the continuance from the July trial date to the September trial date, or is it appealing this decision? Hold on. Instead, he argued that the subsequently granted continuance from the September trial date to the January trial date was a violation of his right to a speedy trial, but he waived that right. Because his waiver was limited to the initial continuance. Let's see what they said. The Idaho Supreme Court unambiguously rejected the notion that a defendant can partially, so kind of like what Kohberger's doing right now, can partially but not fully waive his right to a speedy trial, explaining that Section 193501 does not allow for such a limited waiver. Once the trial has been postponed, the 6-month statutory period no longer applies. Damn, that kind of does feel a little shitty. In this case, the court issued its order for stay after defendant requested a stay under Idaho Code 2-213, which, as the court noted in its order staying time for a speedy trial, is a premature request. Order staying time for a speedy trial, page 1. Instead of issuing a stay under Idaho Code 2-213, the court crafted a limited stay that serves not to halt the proceedings in the traditional sense of a stay, but rather to simply extend the speedy trial period for 37 days. However, the trial was left set for October 2nd, 2023. Although defendant may have stated on the record that he did not intend to waive speedy trial, the practical effort of his motion to stay and the court's subsequent order is that the court had issued an order upon the defendant's application that trial may be set outside of the 6-month speedy trial period. It further complicates matters that defendant had even stipulated to good cause under the very statute that the Idaho Supreme Court cannot allow for limited speedy waivers. See order saying time for speedy trial. This court finds, and Kohberger has agreed, that there is a good cause for the stay, the running of a speedy trial clock for the said period of time. Yeah, so I don't know. Maybe when the judge gets this on his desk, or probably already got it, I don't know, they might not be happy. As a purely practical matter, the parties, witnesses, and victims' family members are now in limbo. Will trial be set out 30 days at the defendant's option or not? If the defendant reviews the grand jury materials and fails, where the hell did it go? If the defendant reviews the grand jury materials and elects to challenge them, will the court issue another few weeks? Hey, happy day. Thank you. Sorry about your Stevie. Thank you. I appreciate the message. Oh, Stevie, I miss you so much. Could more few weeks postponed be forthcoming as other pretrial matters get litigated, such as 12B motions, 404B motions, motions in limine, or death penalty challenges? The state is respectful to the defense's responsibility and need to prepare for trial, specifically the need to review all the materials at issue. But it is the state who carries the burden of proof in this case, an awesome endeavor. So this is where I'm wondering if they're just trying to be facetious, or maybe they meant to say like arduous endeavor and autocorrect just like messed it up. I don't know. What do you guys think about the awesome being in this sentence here? But it is the state who carries the burden of proof in this case, an awesome endeavor requiring the subpoenaing, preparation, and coordination of numerous witnesses. Maybe by awesome, they meant like, maybe there's another like definition of awesome where it just means like, oh, this takes a lot of work and so much effort. many of whom required travel arrangements and other logistical considerations. These witnesses include loved ones, friends of the victims who are undoubtedly anxious for some degree of predictability as this case proceeds. The state is concerned that should the court continue to order such short-term stays, that these witnesses, not to mention the parties, will be left in limbo during a series of tolling periods where short-term continuances could be invoked as a defendant's option. Oh, I feel bad for the family members and the friends too. Conversely, if the court were to consider its order and determine that it was appropriate to rescind that order, nothing would change. Defendant would still be entitled to review the materials that are being prepared and provided. The state would still continue to provide discovery. The parties would still continue to litigate discovery matters and file motions and responses to those motions. Defendant could still elect to seek a stay under Idaho Code 2-213 at such a time as such motion would become ripe. And defendant could still determine whether to waive his right to a speedy trial or proceed in October on the currently set trial date within the speedy trial period. Conclusion. As the court noted in its recent order, this is a complicated and unusual case posing unique challenges to the parties. The state is appreciative of the balancing that the court must do in this case. Oh, I'm glad they wrote a little thing, for the judge. Good to make the judge feel like, okay, we respect you and we appreciate you doing the most as you can. And the court's sensitivity to the needs of the party. But while the defendant undeniably has a right to review the grand jury materials, the law simply does not allow for a defendant to agree to toll speedy trial beyond 6 months and then later invoke his right to a speedy trial. As such, in the interest of protecting the records in this case and in the interest of promoting efficiency and predictability in the weeks and the months ahead, the state respectfully requests that this court reconsider its order setting time for a speedy trial. Signed July 17, 2023, yesterday. You just like Ann Taylor? I don't have any opinions about Ann Taylor yet. I just feel bad because, she kind of just got stuck with this case. And I believe she has to travel 1 hour just to see Kohberger. Because there was only 4 public defenders in that county. And I think none of them were able to do it. There was like a conflict of interest. And so they had to reach out to a different county. Oof. So it's a tough job, it's a tough job. But, what was I going to say? There's something else I was going to say. I don't remember. You're going taco? Want anything? Is it the taco place that Jake was talking about? I don't know if there's a really good recommendations, lengua or anything like that. Sure. Why not? Deed of the Lord ever again. What were they practicing? Did you just keep losing all the arguments? Is that why? So, yeah, we'll wait for all this. But right now, the trial is set for October 2nd. Again, less than 3 months away. So we'll see. I don't know. I don't think it's going to happen. I just feel like a lot of these trials are just going to keep getting push.